Yeah.
All right, we're back.
Yeah.
Thank you, everyone, for that little bio break recess moment and recalibration. We are back doing our jaunt for our open meeting laws, so we better understand what we have and what we're working towards clarifying. So, back to you, sir.
Thank you. And for the record, Tucker Anderson, Legislative Counsel. Let's move into end of part one, beginning of part two. Quickly just note that 1 VSA section 312A sets up procedures under special circumstances where there's either a state of emergency or what is defined as a local incident. And those procedures allow affected public bodies to escape some of the duties that are imposed under 1 VSA section 312, specifically around, for example, hybrid meeting requirements. If you are incapable of meeting at a designated physical meeting location because of one of these hazards, it alleviates this. Unless there are questions about this niche area. Okay. Executive sessions. It is something that is dabbled with in S59, we'll say, the addition of a new basis for an executive session. Executive sessions are entered into by motion. Those motions have to indicate the nature and business of the executive session and must be carried on the affirmative vote of 2/3 of the members present. That's for state government or a majority of members present in the case of a public body. S59 adds a requirement in here that before a public body exits executive session, they hold a vote in the same manner. The vote to enter executive session has to be taken in an open meeting. No formal or binding action shall be taken in an executive session, except for actions relating to the securing of real estate options. Minutes of an executive session do not need to be taken, but if they are, they shall be exempt from public copy and inspection under the Public Records Act. So don't need to take minutes of an executive session, but if the public body does, they're exempt from disclosure under the PRA. Executive sessions in this last sentence in subsection A are broadly prohibited unless you have one of the following bases for entering the closed session. After making a specific finding that premature general public knowledge would clearly place the public body or a person involved at a substantial disadvantage.
From Nugent's hand and then Waters.
Just clarifying that I'm understanding correctly. So the law that we're contemplating for the bill would require the group to take, the body to take a vote to exit executive session. However, minutes are not required. So they might do that and may or may not be record of it.
Correct.
I did. Can you talk about the word disadvantage?
Perhaps.
I just, is it limited to the things that are laid out after that, or is it?
Yes,
Okay.
so these are going to be the bases for the discussion, and disadvantage here. I can provide you later with a Black's Law definition for disadvantage, but what the public body is largely going to be looking at here is the potential for harm, right? And that could take a couple of different forms. It could be the discussion of something that, for example, would harm, the ability of the public body to negotiate with other actors in good faith moving forward because they're revealing strategy. It could impact, the ability for them to have a fair initial petition or response in civil action, right? It can impede their judicial interests and rights, things like that. We'll move through this. Contracts are a basis here after the finding is made, labor relation agreements with employees, arbitration, grievances other than tax grievances, handled by separate procedures, pending or probable civil litigation or prosecution to which the public body is or may be a party. And finally, confidential attorney-client communications made for the purpose of providing professional legal services to the body. So the disadvantage there would be that if that was discussed in an open meeting, you would disrupt the privilege that you have as a client. All right. Move through some of these other bases here, negotiating or securing real estate purchases or lease options. The appointment or employment or evaluation of a public officer or employee, provided that the public body shall make a final decision to hire or appoint in an open meeting and explain the reasons for its decision during an open meeting. But there is a case that clarifies that that last clause does not require that during the open meeting, they provide all of the information that they received for the decision. It was a clear and imminent peril to public safety. And this is one that the committee may want to explore for some of the requests around cybersecurity. Records exempt from the Public Records Act. However, the discussion of the record does not permit an extension of the executive session to the general subject to which the record pertains. So you can discuss the record itself, but the discussion is confined to the record and its contents, not to these subjects related to the confidential record. Academic records or suspension, discipline of students, testimony from a person in a parole proceeding, information relating to pharmaceutical rebate or supplemental rebate agreements, or the security or emergency response measures, the disclosure of which could jeopardize public safety. Another subdivision you may want to consider in the context of the discussion around public safety and cybersecurity discussions. Attendance in executive sessions are limited to the members of the public body and in the discretion of the public body. They may invite staff, clerical assistants, and legal counsel and persons who are subjects of the discussion or information is needed. And that last clause means you can bring a witness who may have valuable input for whatever the executive session is going to be about. Subsection C is very curious, especially given some of this committee's and the Senate committee's discussions about the constitutional authority of the General Assembly. It states that the Senate and the House, in exercising the power to make their own rules, shall be governed by the provisions of this executive session provision, regulating the admission of the public as provided in Section 8 of the Constitution. And as I am certain you have heard in the past, statute is not the Constitution, and it is only binding on the General Assembly in the biennium that is adopted. You cannot bind a future assembly with statute. So this is a very curious subsection.
Yes, Rep. Martin.
Curious in the fact that there's an argument to be made that it shouldn't even exist.
Yes, because under the constitutional analysis that you have received on several occasions, now this statute likely would not be binding on any assembly after the biennium in which it was adopted. And it was adopted in 1974.
That was my next question.
There are some attorney general opinions on this that are cited in the Vermont statutes annotated that come to a slightly different conclusion about the disruption of constitutional authority. And those are opinions from 1974 and 1975.
Have any of the previous government operations committees taken a look at this in a serious way as to whether it should remain?
Not that I'm aware of. I would note the Senate has executive session provisions in its rules, the House does not. The House relies on masons to fill in the blanks. If we are ready, let's talk about penalties and enforcement. Wrap up some of the current statute before you start talking about the requests. A person who is a member of the public body who knowingly and intentionally, so there's the standard, violates the provisions of the open meeting law. A person who knowingly and intentionally violates the provisions of the open meeting law on behalf of or at the behest of a public body. So if you use an agent to violate the open meeting law, or a person who knowingly and intentionally participates in the wrongful exclusion of any person or persons from any meeting subject to the open meeting law shall be guilty of a misdemeanor and shall be fined not more than $500. We have a criminal. Subsection B. This talks about some of the Attorney General's authority with respect to enforcement. The Attorney General or any person aggrieved by a violation of the provisions of the open meeting law shall provide the public body written notice that alleges the specific violation and requests a specific cure of such violation. So again, a member of the public has the opportunity to file this grievance complaint about a violation, but the Attorney General can also step in and has in the past. The public body will not be liable for attorney's fees and litigation costs if it cures, in fact, a violation of this subchapter in accordance with the requirements of subsection B. So first, and you've already visited this, so I'll try not to be too exhaustive in my explanation. Upon receipt of the notice, the public body responds within 10 calendar days by either acknowledging the violation and stating an intent to cure within 14 days, calendar days, or stating that the public body has determined that no violation has occurred and that no cure is necessary. The fact pattern that the representative from Berry City laid out for you is one that is covered in a Supreme Court of Vermont case where, in fact, there was no violation for posting minutes in a location where an individual member of the public could not find the minutes. Failure of a public body to respond to the written notice within 10 calendar days is treated as a denial, which triggers appeal rights. Within 14 calendar days after a public body acknowledges a violation, the public body is required to cure the violation at an open meeting by either ratifying or declaring as void any action taken at or resulting from. So here are the limited bases for curing: a meeting that was not noticed in accordance with subsection 312C, notice requirements, or a meeting that a person or the public was wrongfully excluded from attending, or an executive session or portion thereof not authorized by the executive session provisions. In addition to either ratifying or declaring as void actions taken resulting from one of those three Romanettes, subsection B states that they shall adopt specific measures that actually prevent future violations. So I noted in your discussion of Representative Booten's bill that there's actually very limited bases for curing an open meeting law violation. That's the list. Following an acknowledgement or a denial of a violation or the expiration of the applicable timelines, any person who's aggrieved may bring an action in the civil division. An action may be brought no later than 1 year after the meeting at which the alleged violation occurred. So that's the statute of limitations. You have 1 year to bring your complaint for appeal to the Superior Court. It's under subsection D. The court is directed to assess against a public body that is found to have violated the requirements of the open meeting law reasonable attorney's fees. Now remember, what we just walked through was an opportunity for the public body to escape those reasonable attorney's fees by meeting the timelines and curing any violations if they did in fact occur. And other litigation costs reasonably incurred in which the complainant has substantially prevailed unless the court finds that the public body had a reasonable basis in fact and law, so they were operating in good faith in asserting that no violation occurred, and the public body acted in good faith. In determining whether a public body acted in good faith, the court shall consider, among other factors, whether the public body responded to the notice of the violation in a timely manner. Another option, the public body cured the violation in accordance with subsection B and escapes paying attorney fees and other reasonable litigation costs. Subsection E was added by Act 133. It requires that municipalities specifically post on their website, if they maintain one, an explanation of the procedures for submitting notice of an open meeting law violation under the section, and a copy of the text of the section. So here's your instruction manual for how to complain about an open meeting law violation, either to the public body or the attorney general. And then here's the actual text of the section explaining the procedures. Okay. I was prepared to walk the committee through the COVID amendments, the temporary authority, but so much of it ended up in the open meeting law as we just went through it that it's a little repetitive, duplicative, and unnecessary, even though it is fun to revisit what I invested so much of my time and life into, ultimately like a 3.5 year period.
Okay,
Right, Mango.
thank you. Are there any like real highlights of that remained that you want to highlight for us from the?
Sure.
Yeah.
I mean, just
So
I don't see it.
if there's a brief explanation.
the initial couple issues that were addressed by the temporary authority really related to the requirement for staffing designated physical meeting locations. That was the issue that arose during COVID. Members of the public body could meet electronically, but a staff member or a member of the public body, and this is still in 312A2, were required to be at a designated physical meeting location. And the temporary authority suspended that requirement, allowed for a quorum or more to meet electronically, and then put some procedures in place for how the public was able to access those meetings. Pretty much all of that has carried through into Act 133 and teed up the policy choices that were made, particularly in the Senate discussions, that formed most of what Act 133 ultimately became. So the tension was how to meet the desire of public bodies to continue gathering electronically in lieu of having physical meeting locations. With the reality that there are many places in the state where electronic access might be more difficult. And then later on in their discussion, trying to measure the benefits of electronic meetings for the public and for public access with the burden on some public bodies for broadcasting hybrid meetings. Ultimately, the decisions that were made, as you just walked through, separated the duties and requirements for state public bodies from local public bodies. It created new definitions within the open meeting law to carve out certain types of public bodies that have advisory power, but not any of the other decision-making authority over legislative, quasi-judicial, budgetary, or taxing matters. Right? That's how we got here. There were a few pieces of the COVID response that didn't end up in the open meeting law. The one that immediately comes to mind is that agendas were posted in designated electronic locations in addition to or in lieu of physical locations. There were quite a few lessons learned throughout COVID that shaped the way that language went into Act 133 as well. So initially, there was no requirement for direct access and no requirement for that, link posted in the agenda that allows someone to click and join the Zoom call. Those were all things that got added in subsequent amendments to the temporary authority, based on feedback from folks out in the real world attempting to attend meetings. All right, what I have done based on the committee's request, and I really hope my computer doesn't die, it might, is there a plug here? Again, but
What cord do you need? We got a range.
it's beyond me. I'm gonna start.
Okay, just run with it then. Let's stop talking and let's just work this battery till it goes.
Send me the files.
So what I've done is screen captured the written requests that have been submitted to the committee from various parties. So I have not altered their requests at all. We can work through them and talk about existing law, the proposals in S59, and any necessary policy choices that these requests tee up. And I just went in order of the chronological list of witness testimony on the committee's webpage. So first, request from, I'm going to call it VAPTA, even though I don't know if that's actually what this organization's called.
Sure.
Okay. So their first suggestion under the provisions of S59 relating to the recording of meetings is to exempt in subdivision 6A gatherings of a public body for purposes of a site inspection or field. Policy choice to make here. Talk about the context in just a second. Can't do two things at once on my computer, both because it's dying, but also because I'm just not capable.
I find it hard to believe you're capable of doing.
Very much self-aware though.
All right. So this subdivision applies to local non-advisory public bodies. It states that municipal public bodies and political subdivisions, so your RPCs on here. Except advisory bodies shall record any meeting of the public body and post a copy of the recording in a designated electronic location for a minimum of 30 days. There is an undue burden or undue hardship exception, as you recall. So the request here is to take away site inspections or field visits from this recording requirement.
Mhm. And this is the point where I want to look to the table real quick. Yes.
So
There you go.
how does that reconcile with what you just told us about the fact that it is already in statute that site inspections are exempted currently?
For specific purposes. And to bring you back, those specific purposes are site inspections for purposes of assessing damage or making tax assessments or abatements.
Okay, so that's really specific.
Yeah.
Yeah.
So my understanding is that they would like things like meetings of a board, for instance, for like a training or retreat or that type of thing be included in that particular statute, as well as we heard from another witness. I think it was from a municipality. They were from a municipality asking about tax inspections, but that's already in statute. So that one, we don't have to worry about that. So basically the request is to exempt any gathering that's
For purposes of a site inspection or field visit.
So I don't know how retreats go get into a site inspection for field visit.
You'll visit,
So one thing that I would note, and I think I don't want to pin this on a particular witness, but I think that was from testimony from VHFA talking about certain
Yes.
visits and retreats.
You're right, it was. Thank
One
you.
point to clarify about the application of the open meeting law, we went through the definitions of meetings, and traveling to those sorts of retreats might already be covered by some of the exemptions from meeting for social gatherings, trainings, conferences. And in addition, I think there was some misunderstanding about whether the open meeting law applies to the entire trip, i.e. when they're in their hotel rooms and things like, no, it doesn't. That's it. The definition of meeting does not encompass when members of a public body happen to be in the same hotel.
Report.
Just to go off of that, VHFA also included that they do similarly municipal site visits where they like specifically are in folks' apartments. They wanted to be carved out from that. But they mentioned that minutes are still taken, so they do like a broader review. They talked about what they saw, what they did.
It's a policy choice for the committee to make. I brought it up in the context of the designated physical meeting locations. That's still an underlying requirement for these public bodies. So setting aside some of the hybrid meeting requirements that I believe were discussed in the context of these visiting home visits, essentially, there's an underlying requirement that there be a designated physical meeting location that meets the Title IX public accommodation standards that should also be addressed if you make the policy choice to carve out those sorts of site inspections and field visits. I can give you at a later date the Title IX requirements, but I'm not certain how that would always be accomplished with some of these site visits.
Right.
And in that case, you'll have policy choices to make about total carve-outs from some of the requirements in 312 for site visits and inspections. Versus partial carve-outs for specific purposes or setting aside specific duties such as recording hybrid meetings, things like that. The existing exemption for those abatement and tax site inspections is a total carve-out from the procedures of 1 VSA 312. The next proposal relates to executive sessions in an S59. There is language that is proposed that would require public bodies to list proposed executive sessions when the public body knows that they're going to hold an executive session. And here, BAPTA is suggesting that more information be included, specifically the general topic of the discussion.
Any comment from the table on that one? We're kind of like focusing on these things as to what to really focus more effort on and not. I personally felt that verifying some of that made sense.
Yeah.
I saw Rep Hooper, then Rep Pango.
Would that preclude or interfere with the idea that when you're doing executive sessions for substantial disadvantage that you may include? If you're talking about what the detail you have to go into to describe
Likely not.
personnel action
and-
or property recovery and split something.
Right. To be safe, you could tie the language to the requirement for the motion.
Yeah.
So the motion to go into executive session has to generally describe what the executive session is going to be for. So you could use the exact same language from 1 VSA 313 here to describe what information has to be included in the agenda.
Okay, so it would actually mirror
Right.
agenda to the motion.
Or whatever the motion is going to be. And again, just note, that this requirement is in place for a document that can be amended at any time during the meeting. So the consequence of not meeting the requirement for adding this information to your agenda can be cured during the meeting.
Understood. So they can change it in the moment at the meeting itself, once it's going, but what we're discussing would require, and I'm going to mirror the language of the motion, that the motion, the agenda would mirror the motion, even though they can change it before they get to the motion. Correct? Ish?
Or if it was missing, they would just add whatever the basis for the motion is to the description,
Agenda,
to the agenda.
and then move forward with that as revised, essentially. Rep Waters Evans, then Rep.
I might be going off topic a little bit. Is your question related to this?
On point.
Okay.
And groups that approve the agenda as presented as the first order of business
Mhm.
would not be encumbered by that for changing things later.
They are not encumbered by that because the way that the language is written is that they would add or delete items from the agenda as the first order of business. And then at any point, they can amend the meeting agenda.
I'm gonna save mine because I think we're gonna get to it. Okay.
Rep Engel?
My question was, so if an agenda is posted, for instance, executive session for personnel reasons. If at some point in the meeting, they decided that they don't need to go into executive session for personnel reasons, maybe that person didn't show up or whatever. They could just say, we are not going to go into executive session, we're not gonna have this on the agenda longer.
Right, well, it wouldn't be removed from the agenda, but they could always add
But that's true.
amend it to say that they did not, in fact, and it would be reflected in the minutes as well. This is way more wonky and granular than I expected. Very fun. Okay. Next suggestion, create provisions to exempt working groups or meetings of the members of non-advisory bodies to undertake advisory work. Working groups are commonly used to describe situations when less than a quorum gathers to perform some delegated time-limited work. This one's curious and it shows up later in some other requests that have been submitted to the committee. I'm not immediately aware of a prohibition on public bodies from creating working groups or subcommittees, right, from consisting of less than a quorum. However, as you do this, you may be creating new public bodies, particularly if you're assigning duties of the greater public body to them, right? The definition of public body includes expressly subcommittees. It extends down to all of these other little public bodies that a public body may create to carry out its tasks. In the Senate, there was some brief discussion about at a later time, the context of S59, considering whether for future public bodies of the state, political subdivisions, articulating expressly that subcommittees can be created as an inherent power of the public body. I don't know if that would get to what is being requested here.
You might be saying that one.
Sure. Some of the discussion in the Senate was about for the next time that the General Assembly creates a new board or commission or public body of a municipality, political subdivision, stating expressly that that public body has the authority to create subcommittees. It is an occasional practice of the General Assembly to articulate that there shall be specific subcommittees comprising working groups, task forces, things like that. So
it's nothing prohibiting it, but they're talking about adding it in.
as an express power to eliminate confusion about whether or not certain public bodies are capable of breaking off into subcommittees.
I thought I heard at the very beginning of the presentation that working groups or subsequent smaller bodies that were not making or charged with making decisions were, don't say exempt, but not necessarily
So
subject to.
that is one way to break off the work and navigate some of the electronic and hybrid meeting requirements, would be to establish subcommittees and assign advisory powers, but not any of the other decision-making powers of the public body to them.
No recommendation, it's not a decision by a subcommittee.
Right, strictly advisory.
And when we all got together and traveled around the state visiting marijuana farms, we were not subject to.
You all are governed by the Vermont Constitution and the rules of your chamber. So I'm talking about the open doors provision of the Vermont Constitution, and for your committee, the House rules. Next request, allow executive sessions for the discussion of cybersecurity and public safety. Policy choice, if you want to call out these bases expressly, you certainly can. There are two existing bases that may already cover these generally. But if the feedback is that this is something that should be called out, it's up to you. You have the power. All right, the final note, addressing pornographic content in recorded municipal materials. So we'll call it Zoom bombing, even though Zoom is copyright and a specific product, but Zoom bombing nonetheless. This is actually a Public Records Act issue and request that is being flagged here, right? In the beginning, I talked about Supreme Court of Vermont case. It's Stowe Development Board versus, and then a corporation that has a series of numbers as a name. And the Supreme Court has directed, for purposes of interpreting the open meeting law and the Public Records Act, that they are not to be read in peri materia. So here we're talking about altering a record. It's going to be governed by the Public Records Act. And while I would love to spend 90 minutes walking you through the Public Records Act, because I love it so much, I'll just quickly note that we have excellent guidance from the Supreme Court of Vermont about what is and what is not a public record. Pornographic content inserted against the public body's interests or will into a recording is not going to meet the definition of a public record. And I can provide you with the Supreme Court of Vermont case that analyzes what is and what is not a public record. We can talk about the definition of a public record. But the fear that is being highlighted here is that there is a prohibition against altering or destroying public records unless it is under an approved records management schedule from the state archivist. Doesn't necessarily come into play here, because this would not comprise the business of the public agency that is involved, right? It's not written. I'm not going to be able to move this because my computer just shut down. So you're going to have to kick me out on. I don't know if our time is up or not anyway, but
Yeah.
What I'm going to point to here, because this request comes up again later, is that the blurring, altering, or removal of pornographic content from a recorded meeting is not likely under any of the guidance we have from the courts or under the express terms of the Public Records Act to frustrate a public agency's ability to maintain an official record. So I'll note, we have to do it fairly frequently. There are cameras running in every committee room. We've had Zoom bombings before. We have had folks not realize that the meeting is still running and that they're on Zoom, private parties, witnesses, saying very inappropriate things because they don't realize the meeting is happening that are not part of the legislative record. right?
So that would maybe eliminate the need for a public body to keep two recordings and all the cost that goes along with that. They could just put the.
Right. It's still a good practice. That's what we do. A request comes in. It says we're in Senate Agriculture and someone started broadcasting pornography over our meeting. Say, okay. And we edit the official record, removing the pornography, and we keep an original recording in case there were ever some sort of legal demand for it in the future. So it's a best practice, but again, doesn't meet the definition of a public record.
Chair, I'm certainly up for setting a Saturday morning aside for the 90-minute discussion on.
I mean, however you want to work that into your,
See a Saturday at 9, Bob.
schedule. Sure.
We used to do them in the first week of the session, which I'm sure was brutal, but council attorneys would sit down and do presentations of every area of law that the committee operated in. And it was like a continuing legal education on this is the open meeting law, this is the Public Records Act, this is alcoholic beverages, this is the state lottery system. And in fact, I have one of them here is my handy dandy reference that I used to use for those slideshow presentations on the open meeting law.
We should still do that at least in the beginning of the biennium.
We could have done last one.
There were 6 more pages of requests. You got through the VAPTA requests. There are many more to come. I'm happy to come back to walk through them, discuss the underlying law and tee up the policy choices if that's what the committee would like.
Yeah, that's exactly how we'd like to guide that.
Operative word happy.
Moving on to our final order of business for today. Or I should say, final order of business before lunch. So we took testimony on H364. And that is the annexation of property by the Village of Swanton. After yesterday, it all seemed like the words on the page were amenable and the committee was amenable with moving this forward, correct?
That's.
Yeah.
Okay. Madam Clerk, let me know when you're ready.
Do we need a motion or did you?
too. She's ready. It's motionable, just waiting.
Speaking of,
Conversation about.
it goes on.
Wow.
And then.
Bubble hit dolls.
Yeah.
I know you go like.
You ready to go?
Oh.
All right, folks. So,
Windows.
I am going to, that we find H364 an act relating to approval of the annexation of property by the Village of Swanton. Favor. Barring any other discussion, comment? Call a roll.
Representative Boyden, yes. Representative Pincinel,
Yes.
Representative Morgan,
Yes.
Representative Cooper Brandon,
Yes.
Representative Coffin,
Yes.
Representative Stone,
Yes.
Representative Cooper Randolph, Representative Nugent,
Yes.
Representative Waters Evans.
Yes.
Representative Byron,
Yes.
Representative Hinga,
Yes.
5-0-1.
And if I recall correctly, Representative Hango is going to be the shepherd of this particular piece of legislation.
Correct.
All right. All right, look at that, guys. We voted out a bill for the first time in a little while. Well done. Yeah.
I hope there's not too many amendments.
Yeah, no.
What is, it's the floor.
Gotta refrain from further comments. All right, Autumn, take us off. We'll see everybody back here after the floor and we'll